I'm glad you're watching tonight. Our show is Life Ahead, and we call it Life Ahead because what we try to do on this show is to provide you with information and education on a lot of different topics so that you're maybe more informed when you have to make choices for your life ahead. I'm Sandy Thomson, the host, but the real stars of the show are sitting with me here in the studio. And let me introduce them to you. Obviously, if you watch very often, you know Heidi Adair. Hi, Heidi.
Hi, Sandy.
Nice to have you back with us. Heidi is an elder law attorney, if you recall that, and she's brought another attorney with us. And Danielle, your first time on Life Ahead.
Yes, ma'am.
But you're going to love it. By the end of the show, she's going to say, I want to be on every week. Yeah. It's Danielle Swan, and Danielle is also an attorney. Is elder law your specialty?
Yes, it is.
Okay, so you're learning a lot from Heidi and some of the others. Yeah, exactly. Mm-hmm. Well, our topic tonight is estate planning for every stage of life. Now, I do want you to remember that this is really your show. We're sitting here, but it's really your show. So I welcome you to give us a call here at 969-2720 anytime in the next half hour, and we'll get you some complimentary legal advice right here. And that number will be popping up here frequently during the next half hour. Okay, let's start, Heidi, with you. This is a question I'm sure you've heard. I have no money. Do I have to have a will?
I say it's a good idea to have a will, even if you don't have anything that you feel like is money. You have personal possessions, things, tangible personal property that you should get the chance to say who gets those things. And it also gives you a chance to say who is going to be the person to just wrap up things for you.
Yeah.
I mean, even if you don't have significant assets, just to make sure that your apartment gets cleaned out or your car gets sold, it's important to have those things identified and in place.
Okay, so there's so much. There's just an overwhelming amount of things to do to take care of an estate.
Yeah.
Danielle, power of attorney. We talk about that all the time. Mm-hmm. What is it and why do I need to have one, or do I?
You definitely do, of course. So a power of attorney is a document that you're signing to put someone in place to help you in a situation where you can't handle your own finances or your own medical decisions. So you can appoint the same person for both of those things, or you can appoint different people. But it's in effect while you're still living, but when you aren't able to do those things for yourself. And it basically just allows the person that you select to step into your shoes and do anything that needs done for you that you can't do for yourself during that time.
Well, we've often talked about illnesses here on the show. We've done a lot of shows on dementia and Alzheimer's. If one has dementia, Heidi, how can you make sure that everything is taken care of them financially? Let's say they've selected somebody as a power of attorney. Can that person go ahead and pay their bills, write the checks, things like that?
Yeah, I mean, normally you have to provide the power of attorney document to whatever financial institution you're dealing with. And then that enables you to be able to act just like the person could.
So you go to the bank and take that person with you that is going to take care of that financial work.
I mean, you could do it ahead of time, or if once your person is incapacitated, the person who's going to be the attorney, in fact, takes the power of attorney document, presents it to the bank. The bank will send it through their legal department, they'll review it, and then they'll say, yep, you're cleared, you can write checks or do whatever needs to happen.
So there's always a solution. Always a solution.
There is. And the reason we hammer on powers of attorney so much is that the alternative to that, if you don't have a power of attorney in place and you do lose capacity, is you've got to go to somebody has to go to court to become your guardian. And Danielle is becoming an expert at that. She's had two really, difficult, challenging guardianships that she's had to fight her way through over the last few months.
Well, let's talk about that, Danielle. What's the process? I mean, if somebody passes away and they don't, they didn't have a power of attorney?
They're not passed away. They're alive, but
they're alive. Okay.
They're incapacitated and don't have a power of attorney in place.
Okay, so they have to get a guardian.
Yeah, so the family comes and says, hey, we need to be able to make decisions for mom or dad. And we don't have a power of attorney, and now that they don't have capacity, we can't have them sign that power of attorney anymore. So we have to have them go back to their parents' physician and ask that physician to sign a statement saying that they cannot handle their own affairs, that they're incapacitated, that they have dementia, Alzheimer, whatever it is.
Yeah.
And then we have to take that letter from the physician, we have to file it in the court with a petition, and show the judge this is what's going on. The judge will set a hearing. We have to serve notice of that hearing on all the immediate family members, and then we actually have to go into court. The people that are seeking to be the guardians have to come in with us, the attorneys, as well as, in lots of cases, the actual person that we're trying to get guardianship over.
Yeah.
And we all have to show up there along with, as well, a guardian ad litem, which is usually it's another attorney that's appointed by the judge, that's appointed to talk to everybody that's involved, figure out what's going on, and make a recommendation to the court as to whether or not a guardian really is needed, and whether or not the people that are asking to be the guardians are the right ones to do it.
So the judge makes that final decision.
The judge makes that final decision. So we come in, all of us get there, we tell that whole story, and then the judge makes a ruling on our petition.
Well, from what I know, and I don't know that much about law, but it's the probate judge who handles guardianships? Okay, all right. In Allen County, that's
Judge Hauk.
Judge Howe, who has been on Life Ahead many times.
Yeah.
He's a great guest.
Yeah.
Okay, let's talk about wills and living wills. Is it the same thing, Heidi?
No, a will is the document that says who gets your things after you've passed away. A living will is the document where you say, if I am incurable, I'm going to die within a short period of time, and life prolonging procedures aren't going to make me better, they're just going to keep me alive artificially longer. You're saying, I don't want any of those things when you sign a living will. And then in a living will, you can also say what your preferences are as far as artificial nutrition and hydration if you're at the end of your life.
Where do you keep that? Who knows you have it or don't have it?
Well, you're very much able to provide it to your doctor or the hospital. It's supposed to be in your medical record. I often wonder if it will be found when it needs to be found.
I know,
But
I've been wondering about that. I recall filling one out and answering those questions. I have no clue where it is or
It's probably,
to whom to refer.
I mean, I know we always give it to people in an envelope where we put a copy of their will and their powers of attorney, their living wills in there too. And it's always a good idea to let your decision maker, your power of attorney, know, hey, these things are in my desk or wherever. And so they could go searching for the living will if it came time for that.
I'll tell you, Heidi's a real stickler on making sure that you're organized, right? We've talked about this before when we've talked about estate planning or taking care of some of these end-of-life situations and problems to take care of. And Heidi, I know, I could go to her house and find out where to get everything because you've said it's in an orange folder.
Yeah, it's in an orange book, yeah.
But now, that's the kind of thing, and I bring this up because you want to make sure your family's informed on what you want to do.
Right.
Where your will is, or living will, or all of that. So if you keep it in one place, along with, and I think you've mentioned this, other things that they might need, for example, passwords, account numbers, anything that has to do with finances.
Yeah, a listing of assets is very helpful. And we always do encourage people to have a conversation with their healthcare representative so they know what you want, what your thoughts are about end-of-life things, because you'd be surprised how burdened people are when they have to make decisions for people. And if they know what your thoughts are, it's helpful.
Okay, good. We have a question here. This is from Dave, and Dave says this. He says, I'm my mother's power of attorney. I know legally you guys will shorten that to POA, power of attorney. At what point do I turn over payee status or status to a nursing home? Good question, Dave.
Yeah. So I think you're probably saying that when do you make the nursing home your mom's representative payee for Social Security purposes? And I generally advise clients if you have a power of attorney and the Social Security is going into a bank account, I encourage people to keep control of that themselves. That way you get to say, when is the liability being paid to the nursing home? There's a little buildup in the account. I'm going to run out and go buy my mom something. Yeah. It just leaves you in control. And maybe your mom might go to a hospital for a while. You might not owe the full liability to the nursing home, and then you could use that extra money to buy something extra for her. So I tend to encourage people to keep that job for themselves.
Okay, that's certainly some good advice there. Okay, all right, Danielle, I'm going to come back to you here. Let's say I'm leaving my children a lot of my estate. How can I make sure that they're going to use it the way I want them to?
Of course. There are some things you can do to kind of keep them in check, if you will, after you pass away. Usually what we would do in that situation is set up a trust. And there's a number of different ways that can happen. It can be through the will, or it can be a separate trust document. And we can really kind of tailor that to your situation. If you want to keep funds there until they reach a certain age, or disperse money at certain increments at certain points, we can pretty much do whatever you have in mind for your family.
Do a lot of people that maybe have younger children or grandchildren, do they give specific ages and say, you give my grandson 1/4 of his inheritance when he's 20, another fourth when he's 35, or whatever?
Yeah.
Do they do that?
They do that often, more than not,
Really?
actually. And really, I think I'm starting to see their ages are creeping up. We're getting people that are designating those distributions to happen
Really?
older and older. So yeah, it really, that's money that these parents have worked for their entire lives, and they know their children, and even if they trust that they're going to be financially responsible, they want to make sure that money lasts them and can sustain them as they get age.
Not on a new red Corvette or something.
Right.
Heidi, so you've had this situation with clients?
Yeah. I mean, in many cases, parents are really concerned that they know that they've been providing ongoing support for a child, even beyond their adulthood. And they think, I just want to make sure they're going to be okay in retirement. And the only way that I know how to make sure that's going to happen is to put somebody else in charge of their money so that it doesn't get spent too quickly.
So it could be a guardian, or it could even be a bank?
Well, you refer to the
trustee?
person in charge of the trust as the trustee.
Okay.
And yes, banks can be trustees. Friends, relatives can be trustees.
All right, we have another question here. This is from James, and James says, if I have a piece of paper that had my wishes after death on it, but it's not official, it isn't official, will it hold any legs weight if I pass away before making a will? That's a good question. So maybe I'm interpreting, James, tell me if I'm wrong, that James has written down what he wants, but he's not been to an attorney, so it's not an official will.
Right. So James, unfortunately, that does not work. A will has got to be properly witnessed and signed with certain attestation clauses in it. You can say that's crazy. I know it's job security for Danielle and myself, but they do that just so that it's hard to, fake a will. Somebody under duress could try to make you write a letter to say what they wanted to happen with their property. So unfortunately, you should think about contacting an attorney and getting a will done.
Okay, all right. Danielle, agree or disagree? Or?
Of course I agree. Yes,
Okay.
of course.
Yeah.
And again, these would then become legal documents. Where do they go? Who has the legal document? If it's a will or whatever, who has that?
A lot of times the lawyer who drafted it has the will in their possession.
Okay.
And one other thing kind of in the vein of James' question is that it doesn't work also to try and handwrite your own changes on a will or a trust document. You just would be surprised how many times people come in with documents that they've thought that they,
Crossed out something and
crossed
wrote
something
in
out,
something.
changed it, initialed it, and that doesn't work either.
Well, you need some legal advice, it sounds like.
Yeah.
I want to ask about miscellaneous things. Maybe in your will you've specified what you want done with your house, your car, maybe the lake cottage, things like that perhaps are your assets. But what about smaller things? Who gets the china and the silver and the this and the that? Do you make those decisions beforehand, or do you just let your kids battle it out? They look at you.
It runs the gamut. You have some people that really want to get down into the weeds and designate, certain items. I want this particular dish to go to this person. And then you have other people that just say, I don't care, let them figure it out. It really, we can, again, tailor that to whatever the person's wishes are. Often we'll include a memorandum, which is just a listing where the person can write out things and designate those items. Yes,
okay.
Yes, it is.
Right.
Yep. And so they can designate certain items to certain people to their heart's content if that's what they want to do. Don't have to, but it's certainly an option.
Is that what you attach to the will then, or what do you do with that, Heidi?
Yes.
In the form of wills that we use, we reference the memorandum. It says I might leave a list of who gets certain items, and then you fill out your list at your leisure whenever you want to. You can change the list whenever you want to. And then just make sure it gets put somewhere where somebody will find it. I say to clients, if you want to mail your list to me, I'll stick it with your will so we know it gets found.
Which might be a good idea. Yeah.
Or, share with your kids, here's the list. I hope you guys will honor what it says.
What it says, yeah, exactly.
Yeah.
And I understand one of the popular things now is to label things, like to put, a little Post-it note. Well, that's not big enough for a Post-it note, but a little sign on the bottom of different things. Like who's going to get it?
And that's not necessarily legally binding, that type of program, but it's the rare family that
I think the family would go in and switch the name.
Oh, they could. They could. But we don't get involved in that many personal property disputes. People usually can figure that stuff out.
And a lot of times they've talked that out beforehand. I will tell you, my kids will kill me if they're watching this show. I have 2 adult children. And one day we were cleaning out everything out of the china cabinet and, polishing, cleaning, whatever, putting it back in. And the 2 of them, a boy and a girl, were talking about who's going to get what. I mean, I'm in the kitchen. 8 feet away, I can hear every word they're saying. And I say, well, what if you take and I could have that, and then, and it was like I hollered in and said, I'm still alive.
I'm not done with it yet.
Exactly.
Seems like most families, they're just saying, I don't want to be the one that gets left with all of this mess to deal with. Really,
Right, and that's an issue too. Do you think that, and you've both worked on settling estates, is that more difficult than it used to be, given that a lot of people don't want their parents' things?
Yeah, I mean, that's when you were talking about your kids, I was thinking, well, you should just be glad that they want it, because so many people are minimalists now. They just don't want stuff.
Well, they really are. I mean, because they'll say, well, what would I do with china? When we entertain, we're in the backyard on the grill on paper plates.
Yeah, right. I recently was at lunch with an auctioneer, and I said, talk to me about people's personal property.
Yeah.
And she said, I hate to tell you, but you really hope you raise enough money to pay the people to move the stuff that doesn't sell. You don't generally make a lot of money off of tangible personal property.
Really?
Yeah. Which all the things that we all go to work every day to be able to buy, and nobody wants it. So
exactly. Yeah. A friend of mine said she had, like, I don't know, so many servings of some china, cut glass from Italy, and it took her years to collect as many as she wanted. None of her kids wanted it all.
Oh.
And she has hundreds of dollars invested in that.
Yeah.
Who knows?
Changing world we live in.
It certainly is.
Yeah.
Okay, Danielle, let's go back to you. What do you do if your property is transferred at death if you don't have a will?
Okay, well,
TOD, right? Transfer on death.
Yeah.
Is that something that you decide, like you would also select a beneficiary?
Yeah, that would be something that would actually cause your property to pass outside of your will. So if you do a transfer on death deed, that kind of makes it, well, not kind of, that makes it so that your property is just going to pass straight to that beneficiary that you've designated without having to go through the probate court, and the terms that you put in your will are not going to affect what happens with that that property.
Okay, now tell me if I'm correct. I think from you being on before, Heidi, if you have beneficiaries listed on your 401k or whatever, and you have a will, but they're different, the beneficiary takes precedence. Is that correct?
It does.
Over
it
the
does.
will.
Mm-hmm. Yeah.
Wow.
And
Do
I've
people
had it.
fight that?
Nah, there's not much fighting to be done. Yeah. Nope. It's usually a slam dunk that the beneficiary designation trumps. And I had a client recently come in and say, hey, I want each of my grandkids to get $20,000. And as we were talking, and so I was going to put that in the will. And as we were talking, I found they had beneficiaries on everything, on their checking account, their savings account.
Really?
They'd already done a transfer on death deed to their house. And I said, well, we don't really have any money running
We
through
don't have
the
that
will
$20,000 for
to
each
go
kid.
to the grandkids. So you just got to make all that stuff fit together like a puzzle.
Wow, all right, that's a good example of how things can get complex. So you made a will, and you selected whatever, your power of attorney, your healthcare representative. Danielle, let me ask you this. Let's say that in your will, you have also indicated, who these beneficiaries are, or who's going to be your power of attorney. Can you have more than one? Maybe you want both your niece and your daughter to co-do things?
Yeah, well, just to be clear, so your power of attorney is outside of your will. That's a separate document that's appointing that person. But for both of those situations, so for your personal representative that you appoint in your will and for your power of attorney, healthcare representative, all of those things, you can appoint more than one person. And it's pretty common. In fact, I think we're telling a lot of people it's a good idea. Sometimes, a lot of people would appoint their spouse and their kids as alternate. And I think what Heidi's seeing is as her clients are aging, they want those kids to be able to just help now, even though the spouse is still alive. So, a lot of people are putting more than one person on as a power of attorney, and that's very easy to do. And you can designate, if you want them to be forced to make decisions together jointly, or if they each have independent authority. Can
you say that in your will, that you want them both to sign everything?
I mean, you can, but I caution people to do that. It just, you could have a family situation that warranted it, but if you're in a family that gets along well, to add that extra administrative burden, don't do it.
and sometimes it just gets so complicated in the world we live in now. People are more spread out, and maybe you have 4 kids, but they're living in 4 different states, and to get them all together to sign some document might be pretty difficult.
Even if you're all around, it's just nice to be able to divide and conquer. Like, you take this bank, I'll deal with the BMV, you deal with the house, just to be able to spread the work.
Yeah. Okay, one last question, and Heidi, I'll ask you this, but jump in if you have something to add, Danielle. So you've made your will. You've asked some people to be beneficiaries. Well, you don't have to ask them. You can just name them.
Right.
Should you tell them? Should you tell people or your kids what your will says?
I think that's a personal decision. I kind of say I don't share specifics too early in life because kids may take mental possession of a certain amount of money that they think is coming their way. And your own life may take many twists and turns. You may have healthcare expenses, et cetera, and that may not be there for them when you pass. So I say keep people guessing a little bit.
Keep them guessing a little bit. That's pretty good legal advice.
Yeah.
Danielle, have you had any experience with any of your clients where you've had those kinds of situations?
Yeah, and I find, oftentimes when people are advanced planning, they've had a lot of conversations with their family, and they kind of know what the situation is going to be. But yeah, there's from time to time people like to kind of keep things.
My theory is that that's changing a little bit again with modern times. Because people are spread out or whatever. Wait a minute, you know what? Hold on to that thought because we have another phone call I want to make sure we get to here. And this is from Carol. She said, I had my will done by an attorney but picked up a packet for POA. Will the state recognize that, Heidi?
Picked up a packet for POA.
Power of attorney.
I wonder what that
Like
means.
a legal Zoom, maybe?
Like maybe you did one online or something like that. So oftentimes those online powers of attorney work. Sometimes I do find that they lack powers that you wish that you would have had at certain times. So again, have a lawyer check it out.
Okay, all right. Okay, Carol, thank you so much for watching and for calling in. We're going to have to save my question until the next time you come because our time is up for tonight, unfortunately. But we're going to be back here next Wednesday night. A different topic and some different guests, but once a month we always have attorneys on for sure, so you'll get an opportunity for a lot of legal advice here on Life Ahead. Meanwhile, have a great evening. Stay healthy and stay safe. Good night.
The preceding program on PBS Fort Wayne was made possible in part by
Beers Mallers, elder law attorneys, providing information on legal matters of guardianship and financial issues relating to nursing home care. Beers Mallers attorneys can also assist with Medicaid requirements and help navigate difficult family situations. Beers Mallers, attorneys at law, with offices in Fort Wayne, LaGrange, and on the web at beersmallers.com.